Evening, everyone, and welcome back to the official channel of LegalEdge. Now, before we start with our today's session, just do give me a tech check. Just let me know in the chat box whether I'm audible or not. Audible and visible too. Evening, everyone. Evening. Audible? Good evening, beta. Good evening. Chal. So let's start with our session. I guess we all are done with our CLAT now. And now it comes to the portion of something which is termed as AILET and OLET examination. And AILET or OLET की अगर हम बात करें तो there is certain pattern of questions which become important for the purposes of AILET and other law entrance tests as well, which will include your symbiosis entrance examination, which is in this month only, and you have something which is termed as MHCT. And in दोनों ही examination में pattern of question which is important is principal fact based questions. ठीक है, पीएफ बेस्ड क्वेश्चन इन दोनों ही पोर्शंस में पूछे जाते हैं या इन दोनों ही टाइप ऑफ एग्जामिनेशंस में पूछे जाते हैं. स्लैट में यू विल गेट 12 क्वेश्चंस ऑफ लीगल रीजनिंग. उन 12 क्वेश्चंस में से प्रिंसिपल फैक्ट बेस्ड क्वेश्चंस एंड लीगल जीके क्वेश्चंस भी वहां पर आपको देखने के लिए मिलेंगे. तो अभी हम क्या करेंगे, क्योंकि इन दिस वीक वी हैव एलिट एंड एलिट प्राइमरली टारगेट्स ऑन योर प्रिंसिपल फैक्ट बेस्ड क्वेश्चंस. तो अभी हम यहाँ पर प्रिंसिपल फैक्ट बेस्ड क्वेश्चंस की एक सर्टेन अमाउंट ऑफ नंबर ऑफ क्वेश्चंस की प्रैक्टिस कंडक्ट कर लेंगे. ठीक है, शुरू करें फिर. हाँ जी, shall we start with our session? So we have roughly around 35-40 questions which are important, which are lengthy and which are a bit tricky as well. तो अभी हम उन questions को conduct करना या discuss करना start करते हैं. ठीक है, चलो. So let's start with our session. Do we have any question, guys? किसी का कोई भी questions तो नहीं है? Everything is clear? चलो. So let's start with our question. So this is the first question. Start reading the same, and once you are done with this, just let me know your answer in the chat box. ठीक है, चलो. Start solving the first one. हाँ जी, are we done? Done with the first one? All right. What's the correct answer? हाँ जी, what's the correct answer? चलो देखो. So the principle which was given to us was that every member of unlawful assembly is guilty of the offence committed in prosecution of the common object. तो जहां पर unlawful assembly का एक common object है, उस common object के furtherance में जो भी लोगों ने काम किया उसके लिए उनको punish किया जाएगा. Every such member of the assembly will be punished for that particular offence. Now let's look at the question. So 8 other people, including Ria, traveled to a nearby village to defeat some of her adversaries. Now Ria was hurt during this battle. The opposing party's participants fled. Okay. Now Ria and her friends rejoiced because they agreed that the battle had been won and their fight was over now. They had got revenge for all their past trauma. However, once the opponents had fled, one of Ria's friends pursued them and killed one of them, since she was still angry about them having broken her engagement choose. अब यहां पर क्या आप सबको लायबल करोगे क्या? Because once the opponents started fleeing from that particular side, they were done with that fight which they had, है ना. उसके बाद जो रिया की वन ऑफ द फ्रेंड्स थी जिसने उसको परस्यू किया एंड परस्यू करके जब उसने उसको मारा है, किस ऑब्जेक्टिव की वजह से मारा? वो इस बात से परेशान थी कि उसको रिवेंज लेना था, उसकी एंगेजमेंट जो टूटी उस चीज के लिए. क्या एंगेजमेंट टूटने के लिए जो रिवेंज लेना था, was that the common object of the assembly? That wasn't the common object of the assembly now, and therefore not everyone is going to be punished for this thing. And the correct answer over here was option D, beta, that Ria's friend is solely liable because there was no consensus added with the other parties, and therefore no common intention could be achieved. Okay, so the correct answer in question number 1 was option D. Always stick to the principle which you are given over there and read the factual situations properly. That is the only trick or tip which you will require for solving the question of your AILET or other law entrance examinations. Okay, chalo, let's go. Let's move to the next one. Second question solve करो. तनुज, जो यहाँ पर प्रैक्टिस सेशंस कंडक्ट हो रहे हैं ना, और जो वन लाइनर सेशंस कंडक्ट हो रहे हैं जीके के, उतना फॉलो करते हुए चले जाओ. दैट वुड बी सफिशिएंट फॉर योर लीगल एंड इंग्लिश फॉर द पर्पसेस ऑफ सिम्बाइसिस. ठीक है. हाँ जी, are we done? What's the correct answer in question number 2? Correct, correct. Very good. So the principle was that whoever intentionally puts any person in fear of any injury to that person or to any other, and thereby dishonestly induces the person so put in fear to deliver any property or valuable security or anything signed or sealed which may be converted into a valuable security commits extortion. Now the factual situation were basic हमारे पास extortion की यहाँ पर definition थी. The facts were that Arnav threatens to hit Suraj with a slice of Lapino's pizza unless Suraj gives rupees 5 lakh. Now Lapino pizza contains a high amount of lactin and other lactose related chemicals, and only a few days back Suraj was in the hospital because of a sudden flare up that was almost fatal to him. Now Suraj, who is deathly allergic to cheese, gets scared and gives the money. अब ऑब्वियस सी बात है कि भाई, अब ऑब्वियस सी बात है कि किसी को पिज्जा से कोई प्रॉब्लम नहीं होगी, बट यहां पर एक विक्टिम स्पेसिफिक थ्रेट है क्योंकि उसको एलर्जी है ना. एंड देयरफॉर करेक्ट आंसर वाज ऑप्शन बी, दैट अर्नव इज गिल्टी ऑफ एक्सटॉर्शन सिंस ही ट्राइड टू फोर्स सूरज टू गिव हिम मनी बेस्ड ऑन द फियर ऑफ इंजरी बाय एलर्जीज. ठीक है, चलो लेट्स मूव टू द नेक्स्ट वन. जस्ट गिव मी अ सेकंड गाइस. Guys, just give me a second, है ना. एक सेकंड देना बस. There is some tech glitch. I'll get it sorted and then we'll move to the next one. ठीक है, just give me a second. Yeah, am I audible? Am I audible, guys? चलो, so let's move to the third one. Third question solve करना start करो. Anji, what's the correct answer in question number 3? थर्ड का आंसर इज, चलो देखो प्रिंसिपल क्या था. अकॉर्डिंग टू लॉ अ पर्सन इज डीम्ड टू हैव अटेन्ड द एज ऑफ मेजॉरिटी when he completes the age of 18 years, except in case of a person where a guardian of a minor person or property has been appointed under Guardians and Wards Act of 1890, or where the superintendence of a minor's property is assumed by a court of wards. तो पहली चीज की मेजॉरिटी कब कौन अटेन करेगा, उस चीज को लेकर फर्स्ट प्रिंसिपल था. The second principle was that Indian law expressly forbids a minor from entering into a contract. Hence, any contract entered into by a minor is void ab initio, regardless of whether the other party was aware of his minority or not. Further, though a minor is not competent to contract, nothing in the Contract Act prevents him from making the other party bound to the minor. ये लास्ट लाइन बहुत इंपॉर्टेंट थी क्योंकि दिस पर्टिकुलर लास्ट लाइन वाज एक्चुअली सॉल्विंग दिस क्वेश्चन कि इंडियन कॉन्ट्रैक्ट एक्ट के हिसाब से माइनर कॉम्पिटेंट नहीं है कॉन्ट्रैक्ट के लिए. But again, there is nothing in Contract Act which will stop a minor to bind the other party. ठीक है, अगर माइनर अपने एंड ऑफ द बार्गेन को फुलफिल कर रहा है ना, तो वो सामने वाली पार्टी को भी बाउंड कर सकता है उस प्रॉमिस को ऑनर करने के लिए. नाउ लेट्स लुक एट द क्वेश्चन. The question was that Soumil executed a promissory note in favor of Abhishek, aged 16 years, stating that he would pay Abhishek a sum of rupees 2 lakhs when he attains the age of majority. Now, Abhishek is very happy after making this investment, as he believes he now has enough money for his startup when he turns 18. Now, on attaining the age of 18, Abhishek demanded the amount from Soumil, who refused to pay. Abhishek is furious and wants to take legal action against Soumil as he thinks his right has been violated. Identify the most appropriate legal position from the following. अब पॉइंट क्या है यहां पर कि समीर ने अभिषेक के फेवर में एक प्रॉमिसरी नोट को एग्जीक्यूट किया. If you read the last line of the principle that nothing in the Contract Act prevents him from making the other party bound to the minor, तो इस सिचुएशन में अभिषेक समीर को बाउंड कर सकता है ना फ्रॉम मेकिंग दैट प्रॉमिस. यस और नो? And therefore, the correct answer over here was option D, beta. कि a promissory note duly executed in favor of a minor is not void and can be sued upon by him because he, though incompetent to contract, may yet accept the benefit. ठीक है? And therefore, correct answer over here was option D. क्वेश्चन स्टेम को देखो. क्वेश्चन स्टेम ने ये नहीं पूछा कि अभिषेक के लिए बेस्ट डिफेंस क्या होगा, क्योंकि तुम लोग उस लाइन ऑफ थॉट से ऑप्शन बी और ऑप्शन सी को मार्क कर रहे हो. यस और नो? And therefore, correct answer over here was option D. ठीक है, चलो let's move to the next one. Fourth question solve करो. हाँ जी, what's the correct answer in question number 4th? Correct, very good. So the principle were that the Human Rights Act states that a person has a right to have criminal charges or civil proceedings decided by a competent, independent and impartial court or tribunal following a fair hearing. ठीक है? And the second principle stated that without giving the party an adequate opportunity to state their argument, the court may not proceed ex parte. Ex parte का मतलब क्या होता है, जल्दी से चैट बॉक्स में बताओ. हाँ जी, because legal terms and maxims are important from the perspective of MHCT and SLAT. तो एक्स पार्टी का मीनिंग क्या होता है, जल्दी से मुझे चैट बॉक्स में बताओ. Now, the facts were that Arnav filed a case against Rishabh in the Delhi court for breach of contract, which resulted in damage of rupees 10 lakhs to him. Now, Judge Rohit sent a summon to Rishabh to appear before the court after 7 days. However, due to ill health, Rishabh couldn't appear, due to which another summon was sent to him to appear after a month. However, 10 days before the date of the hearing, the country was struck with pandemic and subsequent lockdown, and again Rishabh was unable to appear due to this reason. Now, enraged with the attitude of Rishabh and owing to the fact that the amount in the dispute was of such a large consideration, Judge Rohit decided to proceed with the case ex parte. Is the action of the judge valid? So the answer is no. ठीक है, आंसर इज नो. वाई? क्योंकि भाई वो ऐसा थोड़ी ना कि जानबूझ के कोर्ट नहीं पहुंच पा रहा था. पहले उसकी तबीयत खराब थी, सब्सिक्वेंटली देयर वाज अ लॉकडाउन इन द कंट्री एंड देयरफॉर ही वाज नॉट इन अ पोजीशन टू मूव टू रीच द कोर्ट. तो फिर ऐसे में आपका कहना कि आपने रीजनेबल अपॉर्चुनिटी से प्रोवाइड कर दी है एंड आप एक्स पार्टी डिसाइड कर दें, दैट वुड गो अगेंस्ट प्रिंसिपल नंबर 2. एंड देयरफॉर करेक्ट आंसर ओवर हियर वाज ऑप्शन डी, दैट नो, as there was a lack of adequate opportunity that was provided to Rishabh due to medical exigencies and due to the pandemic striking and subsequent lockdown that he had to face. ठीक है, चलो. एक्स पार्टी बेसिकली मींस विदाउट हियरिंग द ऑपोजिट साइड. किसी एक पार्टी को सुनकर लीगल प्रोसीडिंग या कोई भी प्रोसीडिंग कंडक्ट कर देना, उसको हम एक्स पार्टी कहते हैं. ठीक है, चलो लेट्स सॉल्व द फिफ्थ वन. हाँ जी, व्हाट्स द करेक्ट आंसर इन क्वेश्चन नंबर 5th? चलो देखो. So under law, persons in possession of the property are entitled to reasonable and quiet enjoyment of the property, failure of which would attract nuisance. ठीक है? Then nuisance is an unlawful interference with a person's use or enjoyment of land or some right over or in connection with it, and nuisance is a damage to person's right to undisturbed enjoyment of his property caused by inappropriate use of other persons. अब यहां पर आप में से जितने लोगों ने ऑप्शन सी मार्क करा है ना, ऑप्शन सी आप लोगों ने मार्क करा सिर्फ क्वाइट टर्म को देखते हुए. बट यू हैव टू अंडरस्टैंड दैट न्यूसेंस इज कंसिडर्ड एज एन अनरीजनेबल इंटरफेरेंस एज वेल. यस और नो? नाउ क्राइंग ऑफ अ बेबी, इज इट इनअप्रोप्रिएट यूज ऑफ द प्रॉपर्टी बाय द नेबर? अगर वो छोटा सा बच्चा रो रहा है, क्या वो प्रॉपर्टी का इनअप्रोप्रिएट यूज हो जाएगा? क्या वो प्रॉपर्टी का अनरीजनेबल यूज हो जाएगा, which can be termed as an unlawful interference with other person's use and enjoyment of the property? Nahi na, that is something which is considered as a reasonable and appropriate use of the property only. भाई अगर आपके पड़ोस में कोई बच्चा रह रहा है और वो रोने लगे, तो क्या आप ये बोलोगे कि भाई आप अपनी प्रॉपर्टी को इनअप्रोप्रिएटली यूज कर रहे हो? राइट? And therefore, see, the question was that Ram and his wife lived happily in a flat in New Delhi during his retirement. A young couple with a kid under 2 months old lived next door and was living on a rental basis. Now, Ram was disturbed by baby's cries both at night and during his midday nap. Who was so irritated by baby's cries, begged the young couple to change their address, but they ignored him. Ram plans to sue the young couple for causing nuisance. अब वो इनअप्रोप्रिएट यूज है क्या, अनरीजनेबल इंटरफेरेंस है क्या? नहीं ना. एंड देयरफॉर करेक्ट आंसर वाज दैट राम विल नॉट सक्सीड. ठीक है, and not succeed में D was not giving any proper reasoning, and therefore A was the correct answer, that Ram will not succeed, as the sound of a crying baby is an expected part of the quiet enjoyment of the property and does not constitute a nuisance. ठीक है, clear everyone? तो न्यूसेंस में हमेशा बस ये मत देखा करो कि क्वाइटनेस ऑफ द प्रॉपर्टी इज गेटिंग इंटरफेयर्ड विथ और नॉट. Understand this thing, that the activity which is being claimed as nuisance should be an unreasonable, inappropriate activity as well. ठीक है, चलो लेट्स मूव टू द नेक्स्ट वन. 7th क्वेश्चन सॉल्व करो. हाँ जी, what's the correct answer in question number 6? 6th का आंसर इज correct, very good. So the principle were that preparation to commit an offense is not an offense, whereas after one has finished preparation to commit an offense, any act done towards committing the offense with the intent to commit it is an attempt to commit the offense, which is by itself an offense. तो basically preparation punishable नहीं है, attempt punishable है. बस attempt में हमें यही देखना होता है that the person must have reached the stage of the penultimate act, जिसके बाद उसके कंट्रोल में कुछ नहीं बचा था. अब वो सक्सेसफुल हुआ या नहीं हुआ वो उसके कंट्रोल के बाहर की बात थी. ठीक है, नाउ फैक्ट्स वर A and B share a very old relationship. B wronged A a long time ago when he stole away A's fiancée. Without care for his old friend, A finally wants revenge and wants to kill B. He buys a gun and cartridges for committing the murder. He then sets out searching for B, and when he sees B, he loads his gun, takes aim at B and pulls the trigger. The gun did not fire. Decide as a judge. सो हमें बस ये देखना है कि अटेम्प्ट किस पॉइंट पे हुआ. ठीक है, कभी भी जब यह आइडेंटिफाई करना हो ना कि एक इंसान प्रिपरेशन के स्टेज से निकलकर अटेम्प्ट के स्टेज पे किस पॉइंट पे पहुंचेगा, तो आप बस ये देखो कि अभी तक उसने जितने भी एक्ट कमिट किए हैं, अगर वो हार्मलेस थे, एंड वो हार्मलेस थे उसकी मर्जी की वजह से नहीं, वो हार्मलेस थे बिकॉज ऑफ समथिंग एल्स एज वेल, तब फिर वो प्रिपरेशन के स्टेज पे माना जाएगा. बट जितने भी एक्ट कमिट किए हैं और वो सक्सेसफुल नहीं हो पाया है, नॉट बिकॉज ऑफ हिज ओन विलिंगनेस, ही वाज अनसक्सेसफुल बिकॉज ऑफ समथिंग व्हिच वाज बियॉन्ड हिज कंट्रोल. मतलब वो अब अटेम्प्ट के स्टेज पर पहुंच चुका होता है. जैसे मानो आप रेलवे स्टेशन पर और कोई आपका वॉलेट चोरी करने के लिए आपके आसपास घूम रहा है, क्या आप ये कह सकते हो उसने अटेम्प्ट कर लिया कि वो आपके आसपास घूम रहा था तो अटेम्प्ट हो गया, वो आपके पास आ चुका था तो अटेम्प्ट हो चुका है? नहीं ना, अभी तक वो पर्सन लौट के भी चला जाता तो कुछ भी ऑफेंस कमिट नहीं हुआ था, कोई भी हार्म कॉज नहीं हुआ था. बट लेट्स से उसने आपके वॉलेट को चोरी करने के लिए आपके पॉकेट में जैसे ही हैंड इंसर्ट किया, पॉकेट खाली थी. अब वो पॉकेट खाली थी, उसकी किस्मत खराब थी, वो तो अपने एंड से सब कुछ कर चुका था ना उस ऑफेंस को कमिट करने के लिए. सिमिलरली एक पर्सन किसी का मर्डर कमिट करने के लिए गन लेकर आता है, टेक्स द शॉट एट द अदर पर्सन, द गन डिड नॉट फायर. द मोमेंट ही पुल्स द ट्रिगर, वो अपने एंड से अब सब कुछ कर चुका है. गोली चले ना चले, सामने वाले को गोली लगे ना लगे, अब वो उसके हाथ में कुछ नहीं था. तो अटेम्प्ट का मतलब वो स्टेज जहां पर सक्सेस या अनसक्सेसफुल होना आपके हाथ में कुछ नहीं, आप सब कुछ कमिट कर चुके हो. तो अगर जब उसने एम लिया, एम लेने को क्या आप अटेम्प्ट मान लोगे? नहीं ना, वो एम लेने के बाद भी अगर पलट के चला जाता तो कोई हार्म कॉज नहीं हुआ होता, एंड वो अपनी मर्जी से हार्म कॉज नहीं हुआ होता वहां पर. तो यहां पर अटेम्प्ट आप इस स्टेज पे मानोगे व्हेन ही पुल्स द ट्रिगर, क्योंकि वंस ही पुल्स द ट्रिगर द गन डिड नॉट फायर, दैट वाज बियॉन्ड हिज कंट्रोल. ठीक है, जैसे मान लो मिर्जापुर से वो अगर कट्टा खरीद के लेकर आया होगा कंट्री साइड पिस्टल, अब वो कंट्री साइड पिस्टल नहीं फायर करी, वो उसकी किस्मत खराब थी, वो तो अपने एंड से सब कुछ काम कर चुका था, राइट? एंड देयरफॉर करेक्ट आंसर ओवर हियर वाज ऑप्शन बी। ठीक है, चलो लेट्स मूव टू द नेक्स्ट वन। 7th क्वेश्चन सॉल्व करो। हाँ जी, 7th का आंसर इज, व्हाट्स द करेक्ट आंसर? Correct, correct. Very good, beta. So the principle was that the acceptance of an offer will be valid only if it is made in the way it was expected to be made. मतलब कि ऑफरर ने अगर कोई एक्सेप्टेंस का मोड बताया है, तो योर एक्सेप्टेंस विल बी कंसिडर्ड एज अ वैलिड एक्सेप्टेंस ओनली व्हेन you have made the acceptance in that prescribed mode only. That was the gist of the entire principle which was given to us. Now, situation was that in order to negotiate the sale of former's store to latter, Ria and Roshni spoke over the phone as soon as price of 10 lakh for the shop belonging to Ria was agreed upon. Ria instructed Roshni to submit her a letter within 2 weeks confirming her desire to purchase the shop at the agreed upon price. Now, Roshni accepted Ria's offer of 2 days later over the phone, but she didn't send her the letter of confirmation until 1 month had passed. Is Ria bound by Roshni's contract? So the answer is no. है ना? आंसर इज नो, बिकॉज आपने उस मोड में एक्सेप्टेंस प्रोवाइड नहीं करी विच वॉज प्रिस्क्राइब्ड बाय द ऑफरर, एंड देयरफॉर करेक्ट आंसर ओवर हियर वाज ऑप्शन बी, दैट नो, because although the acceptance over telephone was conveyed in time but not in the mode specified, and the letter of acceptance was also not sent within 2 weeks. ठीक है, इन सारे एग्जामिनेशंस में बेटा जो आपका सीएलके आता भी है, दैट सीएलके कम्स विद इन द पोर्शन ऑफ जनरल नॉलेज करंट अफेयर्स। लीगल में पर से वो आपसे सीएलके नहीं पूछ रहे होते। ठीक है, प्रिंसिपल फैक्ट बेस्ड क्वेश्चंस जो इन सारे एग्जामिनेशन में पूछे जाते हैं, दे आर प्राइमरली रिलेटेड टू योर स्टैटिक लॉज। वंस और ट्वाइस ऐसा हो जाता है कि मिसलेनियस लॉ पे वो प्रिंसिपल फैक्ट बेस्ड क्वेश्चंस दे दे, अदरवाइज जनरली दे स्टिक टू द पैटर्न ऑफ स्टैटिक लॉज। ठीक है, चलो लेट्स मूव टू द नेक्स्ट वन। 8th क्वेश्चन सॉल्व करो। हाँ जी, व्हाट्स द करेक्ट आंसर? 8th का आंसर इज correct, correct, very good. So the principle was that pilgrimages other than pilgrimages outside India is enlisted in the state list, and the state list exclusive of unions powers. Now, Mr. Ramakant Shukla, a member of the parliament, is a religious man who lives in the state of Bundelkhand. Every year he visits the famous Bhakti temple within the state. However, lately the temple is suffering from a lot of mismanagement due to lack of proper organization. Now, Mr. Shukla wants to introduce legislation in parliament to set up a shrine board which would manage the affairs of the temple. Now, यहाँ पर जो pilgrimage है, that is something which is located within India. And as per the principle, pilgrimages which are other than the pilgrimages outside India is enlisted in the state list. अब ये तो इंडिया के अंदर ही है, मतलब दिस इज द प्रेरोगेटिव ऑफ द स्टेट लिस्ट. अब स्टेट लिस्ट है तो क्या पार्लियामेंट में लॉ इंट्रोड्यूस किया जा सकता है? Answer would be no, and therefore the correct answer over here was option B, that Mr. Shukla cannot bring the legislation as the matter falls within the state list. ठीक है, चल let's move to the next one. ओके बेटा दृष्टि. Chaitanya, the statement stated or the principle stated that the list is exclusive of the union's power. मतलब यूनियन का उसके ऊपर कंट्रोल नहीं है. जब यूनियन का कंट्रोल नहीं है, तो क्या पार्लियामेंट में लेजिस्लेशन आएगा? नहीं ना. इसी वजह से बी आंसर था वहां पर. ठीक है, चलिए भाई, व्हाट्स द करेक्ट आंसर इन द नाइन्थ वन? ठीक है, चलो देखो. Principle was that a proposal cannot be accepted without any knowledge of it. So Jonathan lost his brand new iPad in school. He issued a notice offering substantive reward to anyone who found it. He stuck notices to this effect everywhere. Now Champak Lal, the school sweeper, found the iPad and returned it to the school authorities, who gave it to Jonathan. Now Champak Lal later came to know about the reward money and went to claim it from Jonathan. Jonathan refused to pay the prize money. Is he bound to give it? So the answer is no. ठीक है, so cannot refuse, हटा देते. He can refuse as there was no contract. Again, not a principle based answer, and therefore the correct answer was option D, that Jonathan can refuse to pay because Champak Lal did not know about the price when he returned the iPad. और ये ऑफर को लेकर एक बेसिक सा कॉन्सेप्ट होता है, that you can only accept the offer when you have knowledge of the same. है ना. इसमें हम एक लैंडमार्क केस भी पढ़ते हैं ना. Which case is that? The case is the missing nephew case. मिसिंग नेफ्यू केस का ओरिजिनल नाम क्या था? जल्दी से चैट बॉक्स में बताओ भाई. What was the real name of this particular case? That's the missing nephew case. This case was Lalman Shukla versus Gauri Dutt. Yes or no? इसी केस में तो कोर्ट ने रूल ले डाउन किया था that you cannot accept the offer unless you have the knowledge of the same. ठीक है, चलो let's move to the next one. 10th question solve करो. हाँ जी, what's the correct answer? Correct answer is correct, correct. So the principles were that under Article 21, no person shall be deprived of his life or personal liberty except by according to procedures established by law. The principle two was that right to privacy is enshrined within the ambit of Article 21, and right to privacy is seen as an essential ingredient of personal liberty and is a right of an individual to be free from restrictions or encroachments on his person, whether those restrictions or encroachments are directly imposed or indirectly brought about by calculated measures. Now, the facts were that a foreign expat, was staying in the house assigned to him by the government. The police had been making random and erratic searches at his house without any warrant. The foreign expat had filed a complaint against this kind of police conduct. Unhappy with the complaint, shortly after that, on one particular day, the police carried out a raid at his house without any notice or warrant. Will a foreign expat be covered under the ambit of Article 21? So the answer is yes. Because always remember that जहाँ पे भी fundamental rights में अगर person term use किया है ना, मतलब that is a kind of a fundamental right जो citizen and non-citizen हमने दोनों को provide करा है. And Article 21 में भी person term को use किया गया. That is, no person shall be deprived of his life and personal liberty except according to procedures established by law. And therefore, he will get the protection. And thus, the correct answer over here was option B, that foreign expat will be given protection under Article 21 as it uses the word person and not citizen. Okay? Chalo. Let's move to the next one. 12th question solve. Sorry, 11th question solve. Nahi beta Ananya, at this point of time, considering the pattern of the paper they have been asking for the past few years, I would simply suggest you to just go through as much practice as you can with respect to the principal fact-based question. That would be sufficient beta. है ना? That would be sufficient. Haji, are we done? What's the correct answer? Not that good beta, Anvita. I would suggest just work on as much as you can for the next 2 days. Anything above 9500 is something which is a decent score. Okay? Chal. Correct everyone. So the principles were basically related to the issue of language. So principle one stated that the official language of the union shall be Hindi in the Devanagari script. The principle two stated that it shall be the duty of the union to promote the spread of Hindi language, to develop it so that it may serve as the medium of expression for all the elements of the composite culture of India and to secure its enrichment by assimilating without interfering with its genius the forms, styles, and expression used in Hindustani and in other languages of India specified in the 8th schedule, and by drawing wherever necessary or desirable for its vocabulary primarily on Sanskrit and secondarily on other languages. So language related हमारे सारे के सारे principles given थे. ठीक है? Notwithstanding anything in the foregoing principles, all proceedings in the Supreme Court and in every High Court, the authoritative texts of all acts passed by the Parliament or the legislature of a state and of all ordinances promulgated by the President or the Governor of a state shall be in English language. So first two principles के हिसाब से Constitution ने सेंटर के ऊपर एक obligation impose किया that they should work for the promotion of Hindi. But at the same point of time, third principle ने ये भी चीज clear कर दी that irrespective of the fact that what is given in the above two principles, सुप्रीम कोर्ट हाई कोर्ट की प्रोसीडिंग्स एंड लेजिस्लेचर के पास एक्ट्स या हेड ऑफ द स्टेट के प्रोमलगेटेड ऑर्डिनेंस, इन सब की लैंग्वेज इंग्लिश ही रही. ठीक है. नाउ द फैक्ट्स वर that Pranav Mahanto, a dedicated academician and a propagator of Hindi language, files a petition alleging that it is clear principle that Hindi is the official language of the Indian Union and the Union has been shouldered with the duty to promote it. In this light, the Union is in breach of its duty by providing that proceedings in the Supreme Court and the High Courts and the acts passed by the Parliament and state legislature will be in English language. Is there a breach of duty on the part of the Union? So we just have to figure out that is there a breach of duty? So the answer is no. There is no breach of duty. क्योंकि Constitution में ही वही exception given है. And therefore correct answer over here was option D, that Union is not in breach since principle governing the language of proceedings as English has been laid down to operate irrespective of the official language and the duty to promote it. ठीक है? Always remember one thing guys, which I remembered when I was preparing for my CLAT examination. जितना ज्यादा नंबर्स पे फोकस करोगे ना कि कितनी सीट है, उतनी ज्यादा एंजाइटी और होती है. आपको एक चाहिए, उस एक के लिए जितनी मेहनत हो सकती है आप उतनी करो बस. दैट्स द ओनली थिंग जो अगले 2 दिन तुम्हें ध्यान रखना है. ठीक है. सीटें हमेशा कम लगेंगी. when you are at the other side of the table now, you will always feel कि there is less number of things which is being provided by the other party. बट तुम्हें कितनी जरूरत है बस उस चीज को लेकर फोकस रखो. ठीक है. चलो let's solve the 12th one guys. 12th solve करो. Done. All right. Okay, so we have A and we have C. चलो देखते हैं. So the principles were that negligence as a tort is the breach of legal duty to take care which results in damage undesired by the defendant to the plaintiff. ठीक है. Voluntary non-fit injury. A person who has voluntarily agreed to suffer harm cannot claim damages for such harm. This consent to suffer harm can either be expressed or even be implied. तो negligence की definition दे दी और VNFI क्या होता है इस चीज की हमें definition दे दी वहां. ठीक है. Let's look at the third principle. The third is that the defense of extirpi causa non orator actio means that from a dishonorable cause no action or an action does not arise. ठीक है. चौथा क्या प्रिंसिपल था हमारे पास, that a doctrine of common law states that if a person was injured in part due to his or her own negligence, the injured party would not be entitled to collect any damage from another party who supposedly caused the accident. This is basically the principle of contributory negligence. ठीक है. तो ये 4 प्रिंसिपल्स हमारे पास गिवन थे. नाउ लेट्स लुक एट द फैक्ट्स. The facts were that the claimant Pranay, aged 18, and Arjun, aged 16, were friends. They went out for an evening together. Arjun gave lift to Pranay, okay, on the back of his trial motorbike, which was Suzuki 250cc. He had no license to ride the bike on the road. Indeed, the engine capacity limit for a 16-year-old to ride legally would be 50cc. Now, the pair consumed alcohol at their destination, after which Arjun drove at twice the legal limit for driving. Nevertheless, the pair embarked on their journey home on the motorcycle. Now, witnesses gave evidence to the effect that the two were obviously very drunk, and Arjun was driving recklessly and erratically. So, Arjun was driving, and Pranay was sitting behind him. At one time, Arjun drove dangerously close to a witness in order to scare him. Unfortunately, Arjun hit an oncoming car which was traveling at a very high speed on the wrong side of the road. Arjun was killed, and Pranay was left permanently partially disabled. Now, he brought an action for the injury sustained against the personal representative of Arjun. ठीक है, तो प्रणय ने कार वाले के अगेंस्ट केस फाइल नहीं किया. जब प्रणय ने कार वाले के अगेंस्ट केस फाइल किया होता ना, तब हम सोचते डिफेंस ऑफ कॉन्ट्रीब्यूटरी नेग्लिजेंस के बारे में. यस और नो, है ना. प्रणय ने अर्जुन के रिप्रेजेंटेटिव्स के ऊपर केस फाइल किया है. अब प्रणय और अर्जुन की सिचुएशन में आप कॉन्ट्रीब्यूटरी नेग्लिजेंस का डिफेंस लगाओगे या आप डिफेंस ऑफ वीएनएफआई को अप्लाई करोगे. द डिफेंस ऑफ वीएनएफआई विल बी एप्लीकेबल इन दैट सिचुएशन ना. कॉन्ट्रीब्यूटरी नेग्लिजेंस वाली सिचुएशन तो वो बन ही नहीं रही. यस और नो. And therefore, the correct answer over here was not option C, beta. But the correct answer was option A, that the defense of VNFI may be raised as Pranay was aware of the risk involved in sitting behind Arjun in that intoxicated state. Okay? So the correct answer over here was option A. Clear, everyone? Clear है भाई? समझ में आया? Clear? चलो, let's move to the next one. 13 सॉल्व करो. Point is, Purvi both consumed alcohol, okay? But he was not driving, na? So how will you contribute or how will you designate his negligence in that accident? But the point is, he consented to sit behind somebody who was already drunk. So the consent wala defense comes into picture much more appropriately rather than contributory negligence wala thing. ठीक है? हाँ जी. What's the correct answer in 13th one? 13th का correct answer क्या है भाई? Correct. So an agreement which interferes with the course of justice is void on the ground of being opposed to public policy, and an agreement which conflicts with the morals of the time and contravenes any established interests of the society may be said to be opposed public policy. ठीक है? Facts क्या थे हमारे पास? That Karan promises to pay rupees 25,000 to Shyam, who is named as a witness in the suit against Karan, in consideration of Shyam's promise to abstain from the trial. कि श्याम अगर ट्रायल पे नहीं आएगा तो करण उसको 25,000 रुपए दे देगा. Now Shyam abstains, ठीक है? Shyam abstains, but Karan declines to make the payment. Can Shyam recover the money? Answer is no. ठीक है? Answer is no because your agreement was actually a void agreement, and void को आप enforce कराकर कुछ भी पैसे recover कर नहीं सकते हो. So therefore, the correct answer over here was that no, Shyam cannot recover the money from Karan as the agreement affects the course of justice. ठीक है? चलो, let's move to the next one, guys. 14 solve करो. हाँ जी, are we done? Done बेटा? चलो चलो, करेक्ट, देखो, correct बेटा, correct. So the principle was that for acts done in the course of employment, but not in connection with the sovereign powers of the state, like any other employer, is vicariously liable. Basic सी चीज होती है कि when it comes to the application of vicarious liability on the state, ठीक है, स्टेट के ऊपर जब भी हमें vicarious liability को अप्लाई करना होता है, तो स्टेट के ऊपर के एप्लीकेशन के लिए the functions of the state are primarily divided into two categories: the sovereign functions and non-sovereign functions. Sovereign functions and non-sovereign functions. So sovereign functions are basically those functions which can only be performed by the state, and for those acts the state is not vicariously liable. But when it comes to the non-sovereign functions of the state, ठीक है, नॉन सॉवरेन ऑफ द फंक्शंस ऑफ द स्टेट का मतलब ऐसी एक्टिविटी जो स्टेट के अलावा भी कोई परफॉर्म कर सकता है, उन्हें हम नॉन सॉवरेन फंक्शंस कहते हैं. एंड नॉन सॉवरेन फंक्शंस के लिए द स्टेट कैन बी हेल्ड vicariously liable. This was the principle which was given to us. So the question was that there was a truck which had been part of army division. There was a truck which had been part of an army division which had moved to war front during the 1917 Indo-Pak War. During the movement of this division back to its permanent location after the war, an accident took place injuring few persons and damaging certain properties. At that time, the truck was carrying jawans and equipments. Will the state be held liable for negligent accident? अब वहां पर भले ही negligence हो ड्राइवर का, but still the wrongful act took place in furtherance of the sovereign functions of the state ना. भाई आर्मी का मूवमेंट तो कोई और कर नहीं सकता है, and because it was the sovereign function of the state which was involved over there, therefore the state cannot be held liable, and thus the correct answer was option A, that the state will not be held liable because of the defense of sovereign immunity, as the army truck was returning from war, which can be construed as a sovereign function. ठीक है, example of non-sovereign function: hospital, educational institutions. भाई हॉस्पिटल तो एक प्राइवेट डॉक्टर भी रन कर सकता है ना, एक प्राइवेट पर्सन भी रन कर सकता है. एजुकेशनल इंस्टीट्यूशन भी एक प्राइवेट पर्सन भी रन कर सकता है, हाँ या ना? राइट. So these are kind of activities which can be considered as non-sovereign functions of the state. ठीक है, क्लियर बेटा निशा? चलो लेट्स मूव टू द नेक्स्ट वन. 15 सॉल्व करो. हाँ जी, what's the correct answer in 15th one? Correct. So the principle was that only those offers that the person intends to result in a binding legal obligation constitute valid offers. Now, Karan buys a motorcycle worth rupees 80,000 for the purposes of celebration. He takes his friends to a fancy restaurant. He tells one of his friends, Arjun, that if he pays the bill of the food, Karan will sell his motorcycle to him for rupees 10,000 and then laughs loudly. Arjun pays the bill. Now, this laugh of Karan clearly shows that he never intended to create a binding legal relationship with the other party. Yes or no? तो क्या वहां पर कोई valid contract या valid offer होगा? Again, no. And therefore, correct answer was option B, that Karan never intended to create a binding legal obligation, so the offer made by him will not constitute a valid offer. ठीक है, चलो Let's move to the next one. Solve the 16th one, guys. Anji, what's the correct answer in question number 16th? Chao, देखो. The first principle is that negligence is failure in taking reasonable care to avoid acts or omissions which one can reasonably foresee which would be likely to injure another or some other person. ठीक है? तो basic negligence की हमें definition दे दी गई. The second principle was that the blood alcohol content legal limit is 0.03%. That is 30 units alcohol in 100 ml blood according to 38 milliliter of alcohol and 100 ml blood according to Motor Vehicles Act. Okay? Now, Saruti Suzuki is a renowned company of cars and SUV in India. For more than 50 decades, it has built a trust amongst Indians. Now, Bungs Latin is an Indian actor who is fond of SUV's car. He bought a SUV car, Vriza Vitara. He was so happy with his new car, but in the initial months, he started facing some trouble in car's gearbox. He reported the same to the nearest company-owned service center and took his car to get the problem fixed. In the service center, the new gearbox was replaced by an old gearbox. Now, when Bunk came to take his car, the gear looked fine. While he was driving the car back to the home, the gear stuck and stopped working, because of which he met with an accident. Now, police came and took his breath analyzing test, and it was found that the alcohol level was 40 milliliter per 100 ml of blood. He filed a suit against the company for negligently fitting an old gearbox. The company took the defense that the accident occurred because he was drunk. In this case, what is going to be the correct answer? That whether the company can be held liable or not. Now, his blood alcohol content was 10 ml higher than the prescribed limit. Yes or no? But is the fact anywhere suggesting that the accident took place because he was drunk and driving? Is the fact anywhere suggesting that he was drunk and driving and therefore the accident took place? Rather, the question basically makes it clear, or the factual situation makes it clear, that because the gearbox got stuck, he met with an accident because of that thing. Yes or no? है ना भाई? फैक्चुअल सिचुएशन में तो ये बताया ना कि क्योंकि गियर बॉक्स अटक गया इस वजह से एक्सीडेंट हुआ. एंड न्यू गियर बॉक्स की जगह ओल्ड गियर बॉक्स लगा देना क्या कंपनी का नेग्लिजेंस नहीं है? न्यू गियर बॉक्स की जगह ओल्ड गियर बॉक्स लगा देना क्या कंपनी का नेग्लिजेंस नहीं है? दैट इज एक्चुअली नेग्लिजेंस ना ऑन द पार्ट ऑफ द कंपनी. And therefore correct answer was that the company will be liable. ठीक है? तो not liable के तो options हटा देते. अब C कह रहा है company is liable as it should have checked the gearbox before selling it to bank, and B is saying that Saruti Suzuki is liable as it was a case of negligence on their part. Which one is a principal aligned option? दोनों में से principal aligned options कौन सा है? Option कौन सा है? B or C? B is the principal aligned one now, and therefore correct answer was option B. Okay? Clear? Chalo. Let's move to the next one. 17 solve करो guys. Hanji, what's the correct answer? Okay, so we have D, we have A, we have D. चलो देखो principle क्या था that intention does not matter in case of trespass. One can be made liable if one has entered into someone's land or property without permission. ठीक है? That's principle number one. Principle number two was that the owner of the land can use any reasonable amount of force to keep the trespasser away from his property. ठीक है? अब facts क्या हैं? That Rahul is an 18-year-old boy who loves to play football. He often plays football with his friends in a field adjacent to a bungalow. The owner of the land is Mr. Roshan D'Souza, who is a renowned lawyer and expert in tort law. One evening, while playing, Rahul kicked the ball too hard that it reached the lawn of Mr. D'Souza. Everyone was in bungalow, so nobody got hurt in the incident. Rahul tried to jump the boundary and get the ball. While he was jumping in the lawn, Mr. D'Souza saw him. He thought that it was some beggar trying to steal something and threw his shoes at Rahul. It hit Rahul on his head and he got hurt. Rahul filed a suit of battery and Mr. D'Souza filed a suit of trespass. In this case, now we have to identify two things. ठीक है, दो चीजें मैं आइडेंटिफाई करनी है. That first, whether trespass took place or not, and number two, whether battery took place or not. And both the things are required to be decided in the light of the exercise of private defense as well. That whether the force which was applied was reasonable or not. तो भाई trespass तो उसने किया है, yes or no? Because he was trying to enter into somebody's property without their permission. तो परमिशन के बिना वो एंटर करने की कोशिश कर रहा था प्रॉपर्टी में, तो ट्रेसपास तो है. बैटरी है या नहीं है हमें ये समझना है. अब बैटरी समझने के लिए हमें ये देखना होगा कि वेदर इट वाज अ वैलिड एक्सरसाइज ऑफ प्राइवेट डिफेंस और नॉट. भाई कोई उनकी प्रॉपर्टी पे बाउंड्री वॉल को क्लाइंब करके कूदने की कोशिश कर रहा था बाय स्केलिंग द बाउंड्री वॉल, और उन्होंने अपना शू फेंक के मारा. ही एक्चुअली थ्रू हिज शू एट द अदर पर्सन. तो दैट्स अ प्रोपोर्शनल फोर्स ना. The force which was applied in order to protect the property from an unlawful or without consent wala intrusion, the force was proportional to the threat. तो क्या बैटरी के लिए वो लायबल होंगे? Answer would be no, and therefore two statements are correct over here. That is statement number 1 and statement number 4, and therefore correct answer was option D. ठीक है? Clear everyone? चल, let's move to the next one. 18th question solve करो बेटा. Solve the 18th one. हाँ जी, व्हाट्स द करेक्ट आंसर? क्या करेक्ट आंसर है भाई? Correct, correct. Very good. So the principle was that rule of last opportunity means that he who had the last opportunity of avoiding an accident, notwithstanding the negligence of the other person, is solely responsible. कि अगर आपके पास आखिरी अपॉर्चुनिटी थी उस एक्सीडेंट को अवॉइड करने की, तो नॉट विथ स्टैंडिंग द नेग्लिजेंस ऑफ द अदर पर्सन, सामने वाला पर्सन कितना नेग्लिजेंट था उस बात से कोई नहीं फर्क पड़ेगा, एंड यू विल बी सोलली रिस्पॉन्सिबल फॉर दैट थिंग. Now, facts were that Jagya had a horse and the members of his family used to ride on it. One afternoon, Jagya's son Gulab was proceeding on the horse towards Jamnanagar. When he reached near a bridge called Pulkala, he got down from the horse, held its reins, and waited towards the left side of the road for his father to come and take charge of the horse. At the very time, a motor bus driven by Bansilal was coming from the opposite direction. When Gulab saw the bus, he raised his hand, giving a signal to the driver to stop the bus so that he could remove the horse from the road, but the driver did not pay any heed to his signal and came driving to the bus rashly and negligently towards the wrong side of the road, blowing the horn, and passed by the side of Gulab. The horse on this got frightened, and the bus dashed against a horse, causing serious injury to it, making it permanently lame in this case. Okay? But the point is, the thing is that this person was someone who had the last opportunity to avoid this accident. Na? The bus driver was negligent. We are not disputing that. है ना, बस का ड्राइवर तो नेग्लिजेंट था, उसको हम डिस्प्यूट नहीं कर रहे, बट इसके पास आखिरी अपॉर्चुनिटी थी ना, क्योंकि इसने देख लिया था वो बस ड्राइवर नेग्लिजेंटली गाड़ी चलाकर आ रहा है. एंड देयरफॉर करेक्ट आंसर वाज दैट बंसीलाल इज नॉट गोइंग टू बी हेल्ड लायबल ओवर देयर. ठीक है, गुलाब is liable for negligently leaving the horse. Sorry, just give me a second. The correct answer in this case was Bansilal is liable. Okay, for the negligence in this case, as he had the last opportunity under the rule which he avoided. Okay, let's move to the next one. बेटा, रूल ऑफ लास्ट अपॉर्चुनिटी अब कहीं पे भी अप्लाई नहीं किया जाता है. मतलब उसकी जगह अब टॉट में जिस कॉन्सेप्ट को हम यूज करते हैं, दैट कॉन्सेप्ट इज ऑफ अपोर्शनमेंट ऑफ डैमेज, कि जिसका जितना नेग्लिजेंस था उस एक्सटेंट तक आप वहां पर डैमेजेस प्रोवाइड कर देते हो. ठीक है, तो रूल ऑफ लास्ट अपॉर्चुनिटी अब नेग्लिजेंस के केसेस में एक्चुअली यूटिलाइज कहीं पे भी नहीं होता है. हाँ जी, व्हाट्स द करेक्ट आंसर इन क्वेश्चन नंबर 19th का आंसर इज करेक्ट. करेक्ट. देखो क्वेश्चन क्या था, इन क्रिमिनल मिसअप्रोप्रिएशन whoever dishonestly misappropriates or converts to his own use any movable property commits the offense, and the offense of criminal misappropriation of property is committed where the initial possession is innocent but the retention thereof becomes wrongful and fraudulent by a subsequent conversion for his own use. ठीक है, अब फैक्ट्स क्या है. Atul Savaria was a poor auto driver in Aligarh city. One day he picked some passengers from the railway station and dropped them to the airport. From airport, he picked some other passengers and dropped them to a location. At night, while he was cleaning his auto, he found a lady's purse which had a diamond ring in it. He couldn't figure out the person to whom the purse belonged And in the morning, he again checked in the purse and found a visiting card of Miss Ananya with a phone number on it. He tried to contact Miss Ananya by calling her and visiting the address written on it. He was informed that she had left India and there are very less chance that she would come back again. After all the efforts to contact Miss Ananya, he decided to sell the ring and use the money which he would get by selling. At the shop, he was caught by a police officer in this case. Now, even though he had made all the attempts to connect the other person, but still this case would fall within the ambit of criminal misappropriation बेटा. आप उस प्रॉपर्टी को अपने यूज के लिए कन्वर्ट कर ही नहीं सकते हो. अगर आप उस प्रॉपर्टी को अपने यूज के लिए कन्वर्ट करने की कोशिश करते हो तो दैट स्टिल अमाउंट्स टू criminal misappropriation. And therefore, correct answer in this situation was Atul is guilty of criminal misappropriation as he nonetheless converted the ring for his own use. Okay? So the correct answer over here was option A. Chal, let's move to the next one. Hanji, what's the correct answer over here? देखो, the principle is that state cannot endorse a particular religion. That's the basic principle which is given to us. अब facts क्या है? The facts are that Ajay Veer, a native of Bind, a tribal area in Madhya Pradesh, he served as Principal Secretary of India and he ordered all the states to mandatorily have the idol of goddess Saraswati in all the public offices and made it mandatory. Now, Abdul Wajib Vijahabullah, a native of Habibganj, filed a writ petition in the Supreme Court challenging the constitutional validity of the order. Decide. अब D यहाँ पे इसलिए नहीं हो सकता. That's a suggestive answer बेटा. And though that goes against the principle as well. Facts में ही clearly भेज दिया उन्होंने कि mandatory है. Suggestive हमारा answer D बन जाएगा. And therefore correct answer in this situation was option C. That state cannot showcase a particular religion in the public office. ठीक है? सीधे सीधे हमारा करेक्ट आंसर यहाँ पे था ऑप्शन सी. चलो लेट्स मूव टू द नेक्स्ट वन. 21st सॉल्व करोगे. यू गाइस सॉल्व इट, आई विल बी बैक इन अ मिनट. ठीक है? या आर वी डन? हाँ जी. व्हाट्स द करेक्ट आंसर गाइस? चलो देखो, प्रिंसिपल क्या है, अ डायरेक्टर ऑफ अ कंपनी कैन बी मेड लीगली लायबल इवन विदाउट इम्प्लीडिंग द कंपनी। ठीक है, कंपनी को एक पार्टी बनाए बिना भी आप डायरेक्टर ऑफ द कंपनी को लायबल कर सकते हो, प्रोवाइडेड देयर आर सर्टेन रिक्वायरमेंट्स जिस केस में आप डायरेक्टर को लायबल कर सकते हो, प्रोवाइडेड द पर्सन अक्यूज्ड मस्ट बी इन चार्ज ऑफ एंड रिस्पॉन्सिबल फॉर द कंडक्ट ऑफ द बिजनेस ऑफ द कंपनी। कि बिजनेस के कंडक्ट के लिए अगर वो पर्सन रिस्पॉन्सिबल है, ठीक है, बिजनेस के कंडक्ट के लिए रिस्पॉन्सिबल का मतलब क्या होता है, दैट द पर्सन इज रिस्पॉन्सिबल फॉर द मैनेजमेंट ऑफ डे टू डे अफेयर्स ऑफ द कंपनी। ठीक है, दैट द पर्सन इज रिस्पॉन्सिबल फॉर और द मैनेजमेंट ऑफ डे टू डे अफेयर्स ऑफ द कंपनी। ठीक है, नाउ द फैक्ट्स वर दैट नमन, a final year student of National Law University, decided to sell a pornographic clip of two school students engaged in an act of sex through e-commerce website LOX. According to the rules of the websites, anyone can sell anything through the website at their own risk. Now, an FIR was registered against the managing director of the company for the offences of making available for sale and causing to be published an obscene product. He argued that the clip itself was not made available on the website, and the sale of the video clip was essentially a transaction between the buyer and the seller in this case. Now, first of all, we have to identify that is this person responsible for managing the affairs of the company? क्या ये पर्सन रिस्पॉन्सिबल है कंपनी के अफेयर्स को मैनेज करने के लिए, कंपनी के बिजनेस को कंडक्ट करने के लिए? इज ही इन चार्ज ऑफ दिस थिंग? क्या वो डे टू डे एडमिनिस्ट्रेशन को मैनेज कर रहा है? नहीं ना, यस और नो? द क्लिप वॉज नॉट मेड अवेलेबल ऑन द वेबसाइट ऑल्सो. It basically worked as a conduit or a medium through which person A sold something to person B, right? And therefore, correct answer in this situation was option B, that the managing director is not guilty because he has no intention to sell the obscene or knowledge or no knowledge about the same. ठीक है, चलो तो लेट्स लुक एट द लास्ट क्वेश्चन ऑफ द डे. ठीक है, 22 एंड 23 क्वेश्चन, ये हमारे आखिरी दो क्वेश्चन होंगे. अब इनको सॉल्व करना स्टार्ट करो. ठीक है, हाँ जी, व्हाट्स द करेक्ट आंसर in question number 22? The correct answer is, चलो देखो, प्रिंसिपल क्या है? प्रिंसिपल वन इज दैट बेनामी ट्रांजेक्शन मीन्स अ ट्रांजेक्शन इन विच प्रॉपर्टी इज ट्रांसफर्ड टू वन पर्सन फॉर अ कंसिडरेशन पेड बाय अनदर, बट दिस लॉ डज नॉट अप्लाई इफ अ परचेज इज मेड बाय अ पर्सन इन फेवर ऑफ हिज वाइफ और अनमैरिड डॉटर. बेनामी ट्रांजेक्शन का मतलब प्रॉपर्टी मैं खरीद रहा हूं, पैसे आपने पे किए, प्रॉपर्टी मेरे नाम पे खरीदी गई, पैसे आप मुझे पे कर रहे हो. ठीक है, तो इसको बेसिकली हवाला के लिए यूज किया जाता था, या आपके जो जिसको हम ये कहते हैं ना ब्लैक मनी, ब्लैक मनी की यूटिलाइजेशन के लिए आपके बेनामी ट्रांजेक्शन होते थे. बेनामी ट्रांजेक्शन में क्या होता है कि प्रॉपर्टी इज परचेज बाय वन पर्सन इन द नेम ऑफ अनदर, बट दिस पर्टिकुलर रूल इज नॉट अप्लाइड इन केसेस वेयर अ प्रॉपर्टी इज परचेज्ड फॉर वंस वाइफ और डॉटर. ठीक है, वाइफ या डॉटर के लिए अगर आप प्रॉपर्टी परचेज कर रहे हो, अनमैरिड डॉटर के लिए, वहां पर बेनामी ट्रांजेक्शन नहीं माना जाता. Now, any person who enters in a Benami transaction shall be punished with imprisonment for 3 years, and second is that adultery is a ground for divorce. ठीक है? Now facts क्या हैं कि मुरली विजय, a rich industrialist, has a wife and 2 daughters. He has an extramarital affair with a girl named Kavita. Now Kavita is unmarried and works in his firm. Murli spends most of his time with her, and his family knows about his extramarital affair, but they could not do anything. One day, Murli buys a plot in the name of his concubine. Now, his wife, on knowing about this transaction, files for divorce on the ground of adultery. In this case, is Murli Vijay liable for imprisonment for benami transaction? So the answer is yes. भाई बेनामी ट्रांजेक्शन तो है ना? तो A तो हटा देते हैं. B appears to be a correct one because he has entered into a benami transaction. Therefore, he is liable for imprisonment. Secondly, क्या यहाँ पर exception apply कर पाएगा? Exception given था with respect to wife or unmarried daughter. Yes or no? Wife और unmarried daughter के लिए यहाँ पर exception given था. अब wife और unmarried daughter वाला क्या यहाँ पर exception apply हो रहा है? नहीं ना, exception भी apply नहीं हो रहा है. तो shouldn't D be the correct answer? Both the statements are correct ना? That is statement number B and statement number C. दोनों ही स्टेटमेंट करेक्ट है कि भाई क्योंकि उसने बेजामी ट्रांजैक्शन किया है इसलिए उसको इंप्रिजनमेंट होनी चाहिए. मोरओवर जो एक्सेप्शंस गिवन है वो एक्सेप्शंस भी यहां पर अप्लाई नहीं हो रहे. ठीक है? देयरफॉर करेक्ट आंसर इन दिस क्वेश्चन वाज ऑप्शन डी बेटा. ठीक है? चलो लेट्स मूव टू द नेक्स्ट वन. प्रिंसिपल सेम है, फैक्चुअल सिचुएशन सेम है, बस क्वेश्चन अलग है. क्वेश्चन को रीड कर लो. व्हाट्स गोइंग टू बी द करेक्ट आंसर इन क्वेश्चन नंबर 23? हाँ जी, 23rd का करेक्ट आंसर क्या है भाई? So 23rd का करेक्ट आंसर इज will his wife succeed in getting divorce? So the answer is yes. ठीक है? तो नो वाले ऑप्शंस तो हटा देते हैं. अब यस का प्राइमरी रीजन इज कि बिकॉज अडल्ट्री इज कंसिडर्ड एज अ ग्राउंड फॉर डिवोर्स, है ना? देयरफॉर करेक्ट आंसर वाज ऑप्शन ए एंड नॉट सी, दैट यस शी विल बिकॉज मुरली विजय कमिटेड अडल्ट्री. ठीक है? अब वो जो प्रीवियस क्वेश्चन जिसने भी पूछा था ना बच्चे, होता क्या है कि आप मैनेजिंग डायरेक्टर को या मैनेजमेंट को तब लायबल करते हो व्हेन दे आर एंगेज्ड विथ डे टू डे एडमिनिस्ट्रेशन ऑफ द कंपनी और व्हेन दे आर अवेयर अबाउट एनी अनलॉफुल एक्टिविटी बीइंग कमिटेड इन देयर कंपनी. इन सिचुएशंस में आप मैनेजिंग डायरेक्टर या मैनेजमेंट के लोगों को रिस्पॉन्सिबल होल्ड करते हो इवन विदाउट इंप्लीडिंग द कंपनी. ठीक है? नाउ इन द क्वेश्चन व्हिच वी हैड, क्या वो पर्सन डे टू डे एक्टिविटी के साथ इन्वॉल्व था? Was the person engaged with the day-to-day administration of the company? Was he aware about the fact that some obscene material is being sold on the company? क्या वो अवेयर था? ऐसी सिचुएशन में आप डायरेक्टली मैनेजमेंट को रिस्पॉन्सिबल नहीं कर सकते. एंड देयरफॉर द आंसर वाज दैट द पर्सन इज नॉट गोइंग टू बी हेल्ड लायबल ओवर देयर. ठीक है? क्लियर है? चलो, सो आज के लिए इतने ही क्वेश्चंस. ठीक है? वन इंपॉर्टेंट अनाउंसमेंट, टुमारो वी हैव अ 6 hour नॉन स्टॉप मैराथन जिसमें आपका एनालिटिकल रीजनिंग, क्रिटिकल रीजनिंग, इंग्लिश अलॉन्ग विथ लीगल, ये सारी चीजें कवर होंगी. कल वो मैराथन इफ आई एम नॉट रॉन्ग मेरे ख्याल से ऑलरेडी अलाइन हो चुकी है, तो चैनल पे उसका टाइमिंग देख लेना. सो मॉर्निंग में यू विल हैव जीके का सेशन. ठीक है? दिन में यू विल हैव मैराथन ऑफ रेस्ट ऑफ द पोर्शंस एंड शाम को यू विल अगेन हैव योर जीके का सेशन वाला थिंग. ठीक? तो कल दिन भर का टाइम पीरियड आप यूटिलाइज कर सकते हो एलेट के सारे सब्जेक्ट्स को कवर करने के लिए. ठीक? बाकी अगर अलग से कुछ रिक्वायरमेंट हो या कुछ सजेशन हो, सो लेट अस नो इन द कमेंट सेक्शन वंस द पर्टिकुलर सेशन इज ओवर. ठीक है? रेस्ट, जस्ट टेक केयर ऑफ योरसेल्फ, एंजॉय योर डे एंड आई विल सी यू सून. ठीक है? चलो, थैंक यू सो मच एवरीवन, थैंक यू सो मच गाइस, थैंक यू गाइस, बाय बाय. बाय बेटा, बाय.